Thanks to the PLEA for organizing this webinar. I think this webinar will surely help the students for the LLB exams. So on the last session of this CrPC, I had covered many topics. So, but due to the time constraint, I was not able to complete all the another PPTs. So in this today's PPT, I'll be covering up the another PPTs. So in our today's topic, I'll be discussing about the sessions code, then what is charge and trial, then what is the investigation, then I'll be also covering the summary trial, then the judgment, then we will be also viewing the PPT of this constitution and powers. Then we will also be covering that procedure to followed for rehabilitation and social reintegration of the children. Then I'll also be covering this topic, that is security for keeping the peace for good behavior under the Code of Criminal Procedure. Then there is a maintenance topic, which is a very good topic. Then there is a transfer of cases as to how the cases can be transferred from one code to another code. So I'll begin with the first topic, that is the sessions code. So normally this topic mainly covers the procedures and the step that is followed in trials where the case has come up before the court of sessions. So this is nothing but an initial steps in the trial. So basically initially a magistrate takes the cognizance of an offense, and thereafter as per section 209 he will commit the case to the court of sessions. Say for example, when there is a murder committed in a jurisdiction, then what happens that the accused is produced before the local jurisdiction, that is before the magistrate court. Okay, so what happens that since this is a very severe offense and it has a more a higher punishment, so the magistrate court does not have the power to try and decide this offense. So what he will do, he will commit the case to the sessions court. That means in other words, it means that he will try to transfer the case from magistrate court to sessions court, and so we say that sessions commit case in a practical aspect. So I'll try to explain that in normally what happens that initially a magistrate will take the cognizance of an offense, and thereafter as per section 209 he will commit the case to the court of sessions. So cases are tried and decided by the sessions court. So normally a magistrate is empowered under section 190 to take cognizance of an offense. So upon receiving a complaint, upon a police report, or upon an information received from a person other than a police officer, or upon his knowledge, he will first take the cognizance of an offense. So according to section 193, it says that the court of sessions cannot take a cognizance of an offense directly, but the court of session is permitted to take the cognizance of an offense without a case being committed to it if the magistrate commits the case to it, or if it acts as a special court. So under section 207 and 208, the magistrate is required to supply the copies of the document like the FIR report, the statement recorded by the police, or the magistrate report to the accused. Then under section 209, if it appears to the magistrate that the offense is triable exclusively by the court of sessions, then he may commit the case to the court of sessions and send all the documents and records to it, and either may grant the bail or remand the accused into the custody, and shall also notify to it the public prosecutor. The procedure for trial before a court of sessions is mentioned from section 225 to section 237. So in a short, it means that if the offense is of severe in nature, then the court will try to transfer the case to the sessions court. And in other words, it means that sessions committed case. So whenever there is a sessions committed case, the court, that is the magistrate court, will transfer the case along with all the documents, that is FIR report, the statement, whatever the police station has filed it, they will try to transfer the whole case with along with the documents to the sessions court. Then so when the magistrate commits a case under section 209 to the court of sessions and the accused appears or is brought before the court, the prosecutor is required under section 226 to open his case by explaining the charge against the accused and also states the evidence by which he will prove the guilty of the accused. At this stage, full details of evidence need not be stated. The opening of the prosecution case must be only to matter which are necessary to follow the evidence. It is not necessary for a public prosecutor in opening the case for a prosecution to give full details of the evidence with which he intends to prove the case. So it means that whenever the case is transferred to the sessions court, then they will try to explain the charges which is levied against the accused and for which the accused may lead his evidence. So the court, on considering the documents and records of the case and hearing the prosecution and the accused on the matter, shall discharge the accused if the judge thinks that there is no sufficient ground to proceed against the accused. Normally, what happens now? I'll give you an example. There, the police sometimes make 4 to 5 accused. So, if the judge thinks if the prima facie evidence is such that the offense is only being committed by 2 accused and not by the other accused, then the court, if the court feels that the other accused has not committed the crime or they were not on the crime spot, then the judge can discharge the other accused. So it means that the judge can discharge the accused if the judge thinks that there is no sufficient ground to proceed against the accused. So the judge is also required to record his reasons for discharging the accused under section 227. Take a practical aspect. Say suppose a girl has filed a 498 case before the magistrate court. So he has made the party that is against the husband and against the father-in-law and mother-in-law. Okay, it can be assumed that the 498A was committed by the husband as well as the father-in-law and mother-in-law. But what if the girl has made the parties, that is the relatives, that is the husband's brother and sister? So if the husband proves that the brother and sister were not residing at the flat or they were not residing with them and they were residing at another place, that is the brother and sister of the husband was residing at the another place, then the judge may think that what is the role of the other accused which has been made a party into this case. So in that case, an advocate can move an application before the court saying that the other accused who are wrongly being made a party into this or who have been made wrongly prosecuted into this case shall be discharged. And if the judge finds that yes, there is no sufficient ground to proceed against the 2 other accused, then the judge can discharge the other accused. And if the judge discharges the other accused, then the judge has to record his reasons for discharging the other accused. So I'll give one citation that in the case of state of Karnataka versus Swami, that object of this section is to require the judge to give reasons for discharging the accused, is to enable the superior court to examine the correctness of the reasons for which the sessions judge has held that there is no or is not sufficient ground or this cannot be proceeded against the accused. So in this citation, it also clearly says that if the judge finds that there is no sufficient ground or if there is no prima facie evidence, then the judge can discharge the accused. So now we come to the framing of charge. So under section 228, the judge, after considering the records of the case and the documents submitted along with it in the evidence and bearing the prosecution and the defense, the judge thinks that there is a ground to presume that the accused has committed the offense and is triable by the court of sessions, then the judge will frame a charge against the accused. If the case is not exclusively triable by the court of sessions, then the judge may frame a charge against the accused and by order transfer the case to the chief judicial magistrate or other judicial magistrate of first class. He shall direct the accused to the judicial magistrate to whom the case has been transferred. The magistrate then shall try the case in accordance with the procedure laid down for the trial of the warrant cases instituted upon a police report. So in this slide, we will be covering the topic as to whenever the charge is framed by the judge, then the judge will try to explain the charge, whatever the judge has framed the charges, and that will be explained to the accused. So under section 228, subsection 2 says that when a case is exclusively triable by the sessions court and the judge frames a charge against the accused, then he has to read and explain the charge and ask the accused if he wants to plead guilty or claims to be tried. The judge shall ensure that the charge read and explained to the accused have been fully understood by him before he is asked to plead guilty. Normally, you must have seen in the Bollywood films that the judge always asks the accused, "Do you plead guilty?" Yeah, and you must have also noticed that the accused always says that I do not plead guilty. So what does it means? It nothing. It means that whenever the charges are framed by the judge, then the judge explains that these are the sections that the charge has been framed against you and these are the offenses which has been committed by you. If the accused says that then thereafter the judge asks that do you plead guilty. So normally if the accused says that I do not plead guilty, then in that case the judge records that statement and then after the judge proceed with the trial. If the accused says that yes I plead guilty, then in that case the trial is not proceeded and on the statement of the accused directly a sentence is imposed to the accused. So you must have seen in the Bollywood films in the normal due course of the court also the accused always try to say that I do not plead guilty. So even if the accused is aware that he has committed the offense, he will normally try to say that I do not plead guilty. So whenever the accused says that I do not plead guilty, then the trial commences and all the evidences commence. So in the case of Banwari versus State of UP, the court held that default in reading out or explaining the charge to the accused would not vitiate the trial unless it has been shown that non-compliance with section 228 has resulted in prejudice to the accused. Date for prosecution of an evidence. So under section 230, the judge will fix a date for the examination of witness. If the accused has refused to plead guilty or does not plead guilty, or if he claims to be tried, or if he is not convicted under section 229, then on an application of the prosecution, the judge will issue a process for compelling the attendance of a witness or to produce any document or any other thing. So normally what happens if the accused says that I do not plead guilty, so the judge will try to issue a process or compel the witness to appear before a court to give their statement or to give their evidence. So the judge will fix a date for examination of a witness. That is nothing but a cross examination of a witness. So under section 230, this will be done. Yes. Then it's evidence for prosecution. So as per section 273, all the evidence must be taken into the presence of an accused or in his absence in the presence of his pleader during the course of a trial or proceedings. So whenever an evidence is being produced before the judge, then all such evidences must be in presence of the accused. Normally, you must have seen whenever there is a case committed by the accused, then in that case, you must have seen that there is a party that is state of Maharashtra or the state of Delhi or whatever. Then in that case, the police has to file the evidences. Say suppose the evidence can be CCTV footage or the evidence can be any documents. So in that thing, if the other side, that is the public prosecutor or the state of Maharashtra, give any evidence, then that evidence must be in presence of an accused. This section clearly states that. We are moving to the next slide, that is examination of witnesses. So in this, so when the date is so fixed, as mentioned under section 230, the judge will proceed to take all the evidence that may be produced by the prosecution in his support. So the judge has the discretion to permit the cross-examination of any witness to be deferred until the other witness or witness have been examined or recall any witness for further cross-examination. Normally what happens, the judge will try to issue the process to the witness. So normally if suppose there are 5 witnesses, okay, now the cross-examination of the 5th witness got over, okay, and if the judge feels that yes, the first witness should be recalled for further examination, further cross examination, then the judge has the power to recall the first witness for further cross examination. Okay, so this section clearly states about that. Then under section 137 of the Indian Evidence Act states that the examination of a witness shall be done by the party who calls him, and it shall be so called as examination in chief. The cross examination of the witness is done by the adverse party, that is by the defense. The re-examination is done subsequent to the cross examination by the prosecution. So normally what happens, see, there are two aspects. One is chief examination. Chief examination is means the first witness will state the facts. So it will be a chief examination, and if the other side of the advocate can conduct the cross examination, so we say as a cross examination. Okay, and if suppose there are, I already gave you an example. If suppose there are 5 witnesses, and if the judge feels that the first witness should be recalled for giving the further evidence or for giving the further cross examination, then the first witness can be called for giving the further cross examination. Then under section 138 of the Indian Evidence Act 1872, it lays down the order of examination of the witnesses. It says that the witness should be first examined in chief and then cross-examined. The examination in chief is done by the party who calls the witness, and cross-examination is done by the adverse party. If the party who calls the witness so desires, can be re-examine the witness with the permission of the court. Okay, I'll give you the practical practical case. Say suppose I called a witness. Okay, so what I'll do, I'll first get him to the cross examination box, and first I'll try to ask the questions which are relevant. Okay, so that will be the examination in chief. Okay, now suppose if my other side of the advocate wants to ask the questions, so that he will commit as a that he will ask the questions which will be cross examination in chief. Okay, so remember there are two aspects, that is examination in chief and cross examination. So there are two aspects. Then recording of an evidence. So according to the section 276, the evidence of each witness in all the trials before a court of session shall be written down by the presiding judge himself or under his dictation or under his direction, and superintendence by the officer of the court appointed by the judge in his behalf. So such evidence is usually taken down in a narrative form. The presiding judge may also write it down in question answer form as per the discretion. The evidence so taken down must be signed by the judge and forms a part of the record. So normally you must have seen that whenever there is a cross examination, normally the questions are asked to the witness. Okay, so such cross examination can be recorded in a question and answer form, and sometimes you will find that there are no questions, there are only the answers that are recorded or which have been stated by the witness. So it can be both. Okay, if there is a voluntary statement given by the witness, then the judge has the discretion to record it or not to record it. Normally what happens, the judges are so constrained that they clearly state to the accused that we want the answer only with the particular question, we do not want to hear anything apart from it. If the judge feels that yes, the accused is giving more answer and is voluntarily giving a statement which is relevant to the case, then a voluntary answer can be recorded. And normally the judge also state that the witness has voluntarily stated that. So whenever you will see a cross examination, you can see as such things, that if the witness has given a voluntary statement, then that will also be recorded as the voluntary statement given by a witness. So it has been provided under section 278 subsection 1 that when the evidence of each witness is complete, it shall be read over in the presence of an accused or in his absence in the presence of his pleader, and it shall be necessarily corrected. Also, as per section 279, if any evidence is given in a language that the accused or his lawyer does not understand, it shall be interpreted to the accused or his lawyer in the language understood by him. So normally what happens, that you must have seen that say for example, the accused is not able to understand the English language or any other language. So normally what happens, the advocate or the judge will try to ask the question in the language which the accused is familiar with. Okay, so in a normal courts also, the advocate of the who is conducting the cross examination can ask the questions to the accused in a language which is familiar with to the accused. So Hindi language can also be done for the cross examination if the accused feels that he is comfortable with an Hindi language. Okay, and normally what happens that whenever the cross examination is conducted, then it will be read that these are the questions which was asked during a cross examination, and these were the answers which you have given by the witness. Okay, and the witness can also get the certified copy of the cross examination. Okay, so it's nothing but a copy is also can be taken by the witness that these were the cross examination for which these questions were asked to the witness, and witness has given these answers. Okay, that's the steps to follow the prosecution evidence. So in this slide, we will be knowing the steps which is to be followed for prosecution of evidence. So for procuring the evidence of the prosecution, the following steps have to be followed or mentioned, that is mentioned below. So in this, that is oral arguments and memorandum of arguments on behalf of the prosecution. So under section 314, the prosecutor has to submit his oral arguments after the conclusion of the prosecution evidence and before any other steps in the proceedings are taken. It is also necessary to submit a memorandum in brief stating the arguments in his favor, and a copy of that memorandum should be given to the opposite party. Adjournment for filing a written argument shall only be given if the court thinks proper and record reasons for the same. The court will regulate an oral argument if it thinks that it is irrelevant or not concise. So this nothing, it means that after the evidence, the stage comes that is the oral argument. But before that, it comes the written argument. So normally what happens, see, the advocates will give oral arguments, but it's not in a thing wherein the judge will remember all the things which are orally argued before a court. So normally the judge directs the party to submit a written argument so that whenever an order is to be part or whenever the judgment is to be passed, the judges refer with the written arguments which are stated in brief, and they also see that normally the advocates also highlight that these were the things which we found out during the cross examination. These were the things which the other side has given the evidence which is false or which is true. So written arguments play a vital role before commencing the oral argument. Okay, and based on the written argument, the counsels go for oral arguments. So under section 314, the written arguments has to be submitted. Okay, so under section 313, the court may examine the accused after the evidence for the prosecution has been taken. The object of the section is to give an opportunity to the accused of explaining any circumstances that seems to appear against him after the witness for the prosecution has been examined and before the accused is called upon for his defense. So section 313 subsection 1 and subsection B requires the court to question the accused person generally on the case for the purpose of enabling the accused personally to explain any circumstances appearing in the evidence against him. So normally what happens, the court also asks the accused that do you want to give any more evidences or any more statement which you think that it will be a good defense for you. So this section applies over here. Then it was ruled by the Supreme Court in Shivaji Sahab Rao Bobade versus State of Maharashtra that it is the basic that the prisoner's attention should be attracted to each culpatory material in order to allow him to clarify. Say suppose there are many aspects which the counsels may not clarify the things, and if the accused feels that the case is not going as per his wish, or if he thinks that there are some evidences which have not been properly produced by the counsels or the advocates, then this opportunity is given to the accused, wherein the judge says that do you want to give more evidences or do you want to give any other evidence which can be good for your defense. So this section clearly states that. So that is hearing the parties. So in this section, that is 232, it gives an opportunity to both, that is to the prosecution and to the defense, to address the court before calling upon the accused to enter upon his defense and to adduce evidence in support of it. The comments of the parties should be related to the evidence given by the prosecution and the examination of the accused. So this section gives an opportunity to the prosecution as well as to the defense to address before the court, that is by giving any evidences or any arguments or oral arguments. So this section clearly gives an opportunity to both the parties. Okay, that is order of the acquittal. So in this, if the judge feels that the case does not have any sufficient ground, or if there is no such evidences against the accused, then the judge can give an order of acquittal. So an accused may be acquitted if there is no evidences against him that he has committed the offense. So under section 232, the judge will record an order of acquittal in favor of the accused if he thinks that there is no evidences against the accused that he has committed the offense. Okay, so there is a difference between acquittal and discharge. Okay, so in acquittal, if there is no evidences which the judge feels that he has not committed the offense, then the judge will acquit the accused. And discharge is what? If the judge feels that the other accused who are made the party to the case has not committed the offense, then the judge before the trial itself may discharge the other accused. So there is a difference between acquittal and discharge. Yes, that is steps to follow the defense evidence. So as per section 233, when the accused is not convicted under section 232, then he shall be called upon to produce evidence he may have in his support. If the accused desires that he can give an evidence in his defense in a written form, and the judge shall file it with the record. The steps to be followed for obtaining the evidence of the defense are discussed below. So we will be moving to the next step, that is court witness if any. So as per section 311, that is slide number 20. Yes, court witness if any. So as per section 311, the court can at any stage of inquiry, trial or other proceedings summon or examine any person as a court witness if his evidence appears to the court that it is essential for the decision or for the merit of the case to be decided. So under section 311, the court can at any stage or of an inquiry, trial or other proceedings can summon or examine any person as a court witness. So under this section, the court can. Okay, then that is then arguments. So under section 234, the prosecution shall sum up his case, and the accused or his pleader shall be entitled to reply, and if any point of law is raised by the accused or his pleader, the prosecution may, with the due permission of the judge, make his submission with regard to the point of law. So during an argument stage, it will be all sum up. That is, whatever the evidences which has been filed before the court, whatever there is a cross examination, then there can be a list of documents which must be filed, which have been filed before the court. So all this will be taken into a consideration, and it will be a sum up of everything, and it will be compiled in the arguments. So this section states that under section 234, the prosecution shall sum up his case, and all the accused or his pleader shall be entitled to reply, and if any point of law is raised by the accused or his pleader, the prosecution may, with due permission of the judge, make his submission with regard to the point of law. Okay. Then under section 314 also talks about that the arguments of the parties, that is under section, however, under section 234 provides that after the evidences for the defense is concluded, it is for the prosecution to sum up the case, and then the defense will be entitled to reply. Under section 234 is a special one regarding the argument. So, but whereas 314 is a general provision, and therefore the section 234 would prevail over. So it nothing but states that whatever into the argument stage, everything will be compiled. That is the cross examination, list of documents, everything will be compiled, and it will be sum up in during the argument stage. Okay, that is judgment and connected matters. So after hearing the arguments of the prosecution and defense, the court will give the judgment in a case. So it is a stage wherein the is either acquitted or convicted. So after hearing all the arguments, the judge will decide the case and will give the judgment. So it can be either the acquittal or the conviction. That is judgment. So as per section 235, a judge will pronounce a judgment of acquittal or conviction after hearing the arguments of both the parties. So after hearing the arguments of both the parties, the judge will pronounce the judgment. Okay. And the judge will make the judgment on the basis of point of law, and the judge will give the judgment, and they will give the brief reasoning as to why the judge has given such judgment. The judge will also give the relevant citations. So you must have seen into the judgment wherein the judge normally frames the issues or whatever it is, or normally there is a question of law. So on the basis of question of law, the judge will always say that whether this question has an assertive or a negative. So if there is a negative, the judge give the reasoning. So you must have seen that there is one question or whatever into an order, and the judge give the reasoning part into the judgment. So it's nothing but the reasoning, brief reasoning of the judgment. So in the case of Nakpal Singh versus State of Haryana, it was held that in case of non-compliance with this provision, the case may be remanded to the sessions judge for retrial on the question of sentence. Only if it is not necessary for the judge to hold a new trial altogether, it will be restricted to the question of sentence only. So normally what happens if say suppose there is no proper judgment, or if there is the things that I mean the trial has not been in a fair manner or whatever it is, then in that case the case can be remanded back to the sessions judge for retrial on the question or on the sentence only. So this citation clearly states about that. So, but it will be restricted only to the question of sentence only. That's it. That is procedure to follow the order of conviction. So after the conviction, the judge will hear the accused and then pass a sentence under section 235. Okay. The judge, while passing a sentence, shall try to gather all the information that will influence or relate to the sentence of the accused. So in this section, whenever the judge makes a conviction, yeah, after the conviction, the judge will hear the accused and will pass a sentence. So that will be under section 235. So the judge, while passing a sentence, will try to gather all the information that influences or relates to the sentence of the accused. So the provisions of section 235 subsection 2 are mandatory and should be complied with strictly as per the court. The purpose of section 235 is to offer a chance to the accused to adduce evidence of any mitigating circumstances in his favor. The accused shall be explicitly asked with respect to whatever he needs to state about his sentence, and whether he wants to give any proof on his side in order to mitigate his sentence. So normally what happens that whenever there is a conviction or whenever there is a sentence produced, this is also a section wherein if any proof the accused feels to be submitted before the court, then he can. But normally, this is a very low aspect because whenever there is a sentence, then he only has the right to suspend the sentence and go before an appeal. So in the practical aspect, this has a very low relevance. But this section clearly states that if suppose under this section, it offers a chance to the accused to adduce the evidence of any mitigating circumstances in his favor. So on this point, the apex court in Santa Singh versus State of Punjab held that a judge should first pass a sentence of conviction or acquittal. If the accused is convicted, he shall be heard on the question of sentence, and only then the court shall proceed to pass a sentence against him. So in the case of Bachchan Singh versus State of Punjab, it was ruled by the court that this section provides for a bifurcated trial and specifically gives to the accused person a right of pre-sentence hearing, which may not be strictly relevant to or connected with the particular crime under inquiry, but may have a bearing on the choice of the sentence. That is procedure in case of previous conviction. So under section 236, it talks about the previous conviction. It says that if an accused is charged with a convicted previously under section 211 subsection 7 and he does not admit that he has been previously convicted with the alleged charge, the judge after convicting the accused under section 229 or section 235 may call for evidence of the accused of such previous conviction and shall record the findings. In case the accused is liable to enhance punishment or punishment of a different kind, the provision to this section mentions that such charge shall not be read out by the judge, nor shall the accused be asked to plead, nor shall the prosecution refer to such previous conviction. So normally what happens, whenever there is an offense, the judge also takes into an account that whether the accused has committed any other crime. If yes, then such things are also stated into the current case, because it helps the judge to find out whether the person is a habitual offender, and if suppose he has been convicted, previously convicted, then that things are also been mentioned. And if the judge feels that it was wrongly mentioned by an counsels or whatever, then the judge may say that you bring such evidences which you feel that it was you were not convicted into an offense or whatever. So this section clearly said that if he was convicted, then he has to the judge will have to record such things into the relevant cases. Section 236 also provides for a special procedure for determining the liability to enhanced punishment as a consequence of a previous conviction. Say suppose the accused has committed the offenses numerous times, and it has come into this case wherein it is produced that in the similar case the accused was given the punishment, still the accused has committed the similar offense next time, that is the second time, then the judge will give an enhanced punishment. So this section clearly states that under section 236, it provides for a special procedure for determining the liability to enhanced punishment as a consequence of a previous conviction. Procedures in case of defamation of high dignitaries and public servants. So under section 199 subsection 2, the court of session may take cognizance of an offense without the case being committed to it when any offense of defamation is committed against a person who is at that time, that is President of India, the Vice President of India, the governor of a state, or any public servant in the union or state, when a complaint is made to it by the public prosecutor in writing. Section 237 requires that the court of sessions to try the case in accordance with the procedure for trial of warrant cases instituted otherwise than on a police report before a magistrate court when it takes cognizance of an offense under section 199. So each trial under section 237 is to be conducted in camera if the court thinks or if either of the party so desires. So if the court discharges or acquits any of the accused and the court thinks that there is no reasonable cause of making an accusation against the accused or any of them, a show cause notice for grant of compensation may be issued to those allegedly defamed. So this cases states that when there is a false cases filed against any persons or whatever it is, then in that case a compensation can be given for causing the defamation. So that is conclusion. The code for criminal procedure provides an opportunity for the accused for fair trial and makes an effort to avoid any delay in investigation or trial. So the judge in every case ensures that the accused is given a fair opportunity and the trial should be in a speedy manner. The code also provides that there should be a legal aid provided to the accused who is unable to engage a lawyer. So if the person is unable to engage a lawyer, then he can give an application before the judge that I am unable to engage a lawyer, and so a lawyer from the legal aid cell may be provided to me. So in certain cases also the judge can provide a free lawyer or a lawyer which is of a nominal charge or whatever can be provided by the court from the legal aid to the accused. So with this we conclude this topic, that is charge and trial. So normally the charge means that it is informing the accused persons on the grounds on which the accused is charged. A charge is defined under section 2B of the CrPC 1973, which states that the charge includes any head of the charge and the charge contains more than one head. So in the case of VC Shukla versus State, it explains the purpose of framing the charge is to give intimation to the accused. So normally what happens that whenever the charges are framed, the judge informs the accused that see, these are the charges which has been framed against you and these are the offenses which has been committed by you. So it means that this is the charge, okay, that is framing of the charge. So the provisions which deals with the charge is that the charge is dealt under chapter 17 of the criminal procedure code. So under section 211 to 14 it is the contents of the charge. Then from section 216 to section 217 it is the powers of the court to alter the charge. Then under section 218 it is the basic rule. Then 219, 220, 221 and 223 are the exceptions. Then 224 is the effects of withdrawal and section 215 and 464 is the effects of errors. So we are moving with the next slide, that is form and content of a charge. So under section 211 of the CrPC, there are the essential elements of the contents of the charge. That is, the charge shall form the state of the offense for which the accused is charged. Okay, the charge form shall specify the exact offense name for which the accused is charged. So if there is no specific name given under any law for the offense which the accused is charged with, then the definition of the offense must be clearly stated in the charged form and informed to the accused. The law and provision of the law to be mentioned in the charge form. Then the charge shall be written in the language of the court. Then the accused shall be informed about his previous allegations, which would expose him to enhancement of punishment if found guilty of the for the offenses charged. The basic rule regarding the charge and its trial is that the initial requirement of a fair trial in criminal cases is a precise statement of the accused. So normally what happens that there should be a fair trial and the Supreme Court also holds that the written statement filed by an accused in a trial must be taken into consideration before convicting him. So the statement plays a very vital role, and whatever the statement is filed by the accused must be taken into a consideration, and on that basis it plays a very vital role before convicting him. Then we are moving with the next slide, that is exceptions to the basic rule. So under section 219 of the CrPC, it says that when a person is accused of an offense of more than one, but not exceeding three of the same kind, and the offense is committed within 12 months, then the accused may be charged and tried at one trial for all the offenses committed. So the offenses are said to be of the same kind when they are punishable with the same amount of punishment under the same section of Indian Penal Code or any special law or local laws. So it says that if the person who is accused of an offense of more than one but not exceeding three of the same kind and the offense is committed within 12 months, then the accused may be charged and tried at one trial for all the offenses committed. That is case history of exception number 1. So in Madan Mohan Sahu versus Central Agencies 2010, checks were issued within 12 months. The court held that it was not necessary to file two separate complaints against their dishonor, and it is enough if a single complaint is filed. So normally what happens if the checks were issued within 12 months? The court said that it is not necessary to file two separate complaints against their dishonor, and it is enough if a single complaint is filed. That is under section 220 of subsection 1 of the CrPC. When the accused commits several offences in the same transaction, then he may be tried jointly, and it is immaterial whether the offence is of same kind or not, or whether the number exceeds 3 or not, and whether the offence is committed within 1 year or not. Then there is a citation, that is Mohinder Singh versus State of Punjab. In this case, it was held that the court may or may not try all the offences together in one trial. So it is the discretion of the judge whether to try all the offences together or not. Now we are moving with the exception number 3, that is section 220 subsection 2 of CrPC. When the accused is charged with one or more offences of criminal breach of trust or dishonest misappropriation of property, the accused may be charged with and tried at one trial for every such offence. So this is also an exception which is stated under section 220 subsection 2 of CrPC. Now we are moving with the exception 4. That is section 220 subsection 3 of the CrPC states that when the accused is charged with an offence which is falling under two or more separate definitions of law, then the accused may be charged with or tried at one trial for each of such offences. So there is one case history wherein in Ramayan Bhagat versus the state 1968. So in this case, it was said that a man may be prosecuted under section 7 of the Essential Commodities Act 1955 for having a rise above the prescribed limit, and also for dacoity in respect of the same bags of rice. So these are the exceptions which has been stated under section 220 subsection 3 of CrPC. Then we are moving with the exception number 5, that is section 220 subsection 4 of the CrPC, that when the accused commits several acts and one of which constitutes an offense, and when it is combined constitutes a different offense, the accused person may be tried at one trial for the offense constituted by such acts when combined, and for any offenses constituted by any one or more of such acts. Say for example, A commits robbery on B, and in doing so voluntarily causes hurt to him. A may be separately charged with and convicted of an offense under section 323, 392 and 394 of the IPC. So I think everyone is getting clear an idea as to that if a person commits many offenses, that it can be constituted on a one trial and it can be tried on a one trial. Okay, that is exception number 6. So under section 221 of CrPC, it lays down a few conditions that when a single act or a series of acts is of such a nature that it is doubtful whether offense the accused has committed, then the accused may be charged with having committed all or any of such offenses, and the charges against may be tried at once, or the accused may be charged in the alternative with having committed someone of said offenses. So when the accused is charged with one offense, but it appears that in the evidence there is altogether a different offense for which he is charged, then the accused is convicted for the offense only which he committed, although he is not charged with it. This section is applicable only in cognate offenses such as theft and criminal breach of trust, and it does not include offenses such as murder and theft. That is case history of exception number 6. In the case of Achut Rai versus Emperor, in this case, where the accused is charged with murder under section 302 of the IPC, the accused cannot be convicted under section 194 of the Indian Penal Code. So there are the exceptions to it, which says that if the accused is charged with murder under section 304 of the IPC, then the accused cannot be convicted under section 194 of the Indian Penal Code. Then we are moving with the exception number 7, that is section 223 of the CrPC, which provides that certain persons can be tried jointly. So who are the persons who can be, it provides the certain persons which can be tried jointly. So what this section speaks about, we will see into this lecture that, see, the number one is that accused who has committed the same offense in the same course of the transaction. Then second one is accused of an offense and a person accused of abatement or of an attempt to commit such offense. Then there is an accused of more than one offense of the same kind and committed by them jointly within 12 months. Then accused of different offenses committed in the course of the same transaction. Then accused of an offense which includes theft, extortion, cheating, criminal misappropriation, concealment of property. Then where the accused of offenses under section 411 and 414 of the Indian Penal Code. Then the proviso to section 223 of the CrPC also provides that the magistrate, on an application of the accused person, may direct their joint trial even if they do not fall under the categories specified, if the magistrate believes that the trial of such person would not be prejudicially affected. So normally what will happen that if suppose there are two trials, okay, so judge can direct that there should be a joint trial and it will be decided all together. So this uh, can also be done during the criminal trial, that is conviction of an offense not charged when such offense is included in an offense charged. So under section 222 of the CrPC, it says that when an accused is charged with several offenses and some of which when combined and proved form a complete minor offense, then the accused may be convicted of a minor offense though he was not charged with such minor offense. Where the accused is charged with an offense, he may be convicted of an attempt to commit such offense, although the attempt is not separately charged. So this section applies only when the major and the minor offenses are cognate. That is withdrawal of remaining charge on conviction on one of several charges. So section 224 of CrPC states that when the accused is charged with more than one head, and after the conviction of the accused under that head, then either the complainant or the officer conducting the prosecution may withdraw the remaining charge with the consent of the court. So in the case of Vibhuti Narayan Chobe versus State of UP in 2002, in this case a charge can be withdrawn under this section only after the judgment and it cannot be deleted. So we will be moving with the next slide, that is effects of error. So under section 215 and 464 of CrPC, it deals with effects of errors. The idea behind this section is to prevent failures of justice where there has been an only technical breach of rules, and while not going to the roots of the case as such. Section 215 of the CrPC states that there shall be no error or omission either in stating the offense or the particulars which are required to be stated in the charge, and they shall be regarded as material at any stage of the trial unless the accused was misled by such error or occasioned as a consequence, and a consequence it has failed justice. So in the case of Bhagat Das versus the state of Orissa, 1989, in this case, the court held that insignificant irregularities in stating the particulars of the offense in the charge will not affect the trial or its outcome. That is conclusion. So in a criminal trial, the charge is the foundation of the accusation, and every care must be taken to see that it is not only properly framed, but the evidence is only tendered concerning the matters put in charge and not the other matters. So with this, we complete the topic, that is charge and the trial. Now we are into the investigation topic. So there is a procedure for investigation under CrPC. So whenever any crime happens in a society, the first step for the investigation crime begins with the filing of an FIR. So how an FIR has to be filed and what the FIR has to be recorded is all stated into the CrPC. So under section 2H of this code defines the term investigation as all the proceedings conducted by the police officer to collect the evidence associated with the crime. That is sections. So at the beginning of any investigation, the crimes are identified as cognizable and non-cognizable offense. And then according to the nature of the crime, the investigation proceeds. So section 156 to 173 covers all the stages and the method as to how the investigation should take place. So you must have seen that if there is a cognizable offense committed by any person, then the police can investigate into the case and lodge an FIR. But however, if there is a non-cognizable offense committed by an accused, then the police will not investigate into the case and an FIR cannot be filed under non-cognizable offense. So whenever you must have also seen that whenever you visit to the police station or something, and for a minor issues or petty issues, the police file a NC. What is NC? That is non-cognizable offense. So for that non-cognizable offense, the police does not take any action against the person. It's just a mere recording of a non-cognizable offense. The police will not investigate into the case and no FIR will be filed in non-cognizable offense. So you must have always seen that whenever you visit to the police station and if there is any petty issues committed or a very minor offense committed, and then in that case the police lodge an NC, that is nothing but a non-cognizable offense. Then what are the steps of investigation? So the authority of the police to investigate a crime is mentioned under section 156 of the CrPC. So the investigation mainly consists of the following steps, that is filing of an FIR, then investigating the location of the crime, then collecting the evidence, then interrogating the relevant persons, then finding the suspects, then filing of a charge sheet. So if the court feels that the person is innocent, then there is acquitted. If the court feels that the person is guilty, then the punishment is awarded. So this is the very vital role of an investigation. Then what is a cognizable offense? So cognizable offenses, we are moving to the next slide, that is cognizable offense. So cognizable offenses are the offenses in which the police can arrest a suspect even without an arrest warrant. These are the serious kind of offenses in which the punishment is more than 3 years, with or without fine. So the crimes like dowry, murder, rape, etc. fall under this category. So it is defined under section 2C of the CrPC. So it is nothing but an offense which is against the public at large. Now we are moving with the next slide, that is what is non-cognizable offense. So non-cognizable offenses are less serious in nature, for which the punishment is less than 3 years, with or without the fine. In these kinds of crime, an arrest warrant is required to be made to arrest the person. So crimes like defamation, battery, assault come into this category. So it is defined in section 211. It is defined in section 2 subsection I of the CrPC that if any case involves both cognizable and non-cognizable offense, then the case would be treated as one involving a cognizable offense, right? That is authority to investigate. So according to the CrPC, section 156 confers upon the police officer the power to investigate a cognizable offense. This section empowers the police officer to begin with an investigation of the case with or without the orders of the magistrate. They are enabled to investigate such cases which come under the jurisdiction of the police station. In the cases of a cognizable offense, the police in charge of the police station has to file the FIR in written form and get the same signed by the petitioner, that is the complainant. Only then the investigation will start. The magistrate can also the investigation of a cognizable offense under the power given to him by under section 190. So the police will investigate. So normally what happens that whenever see, I'll tell you the steps. Whenever a complaint is given to the police station, the police first takes the complaint and see whether it's a cognizable offense or a non-cognizable offense. If it's a cognizable offense, then the police will investigate into the case and will after investigation the police will lodge an FIR. If it's a non-cognizable offense, then the police will not investigate into the case and most probably the FIR will not be lodged against the person. But if the person feels that an FIR is not filed against the person, then the court approaches to the magistrate court, and then the magistrate court can direct the police officer to lodge an FIR. So we can see that the magistrate can also the investigation of a cognizable offense under the power given to him by a section under 190 of the CrPC. So a person can also approach to the magistrate court that directing the police authorities to investigate into the case. And this is what the section speaks about. Now we are authority to investigate. So that is FIR. What are the powers of the police officer? That is FIR, then its investigation, then its inquiry, then they also report on the suicide, then its powers as per laid down into the Police Act, then its power to require the attendance of the witness. So these are the powers of the police officer. Now we are moving to the next slide, that is information of the crime. So this is the first and the most important step of the investigation. So whenever the crime happens, it is the responsibility of the victim to inform the nearest police station that see such crime has occurred in this jurisdiction, and this can be done either in written form or an oral form. If the information is given orally by the victim, then the police needs to get it done in writing, and it is signed by the victim also. After this, the police will file the FIR report, that is first information report as per the information provided by the victim, and a copy of the FIR will also be given to the victim free of cost. So I would like to conclude this topic that investigation is a long and a lengthy process. However, this is to make sure that the investigation is done properly, keeping all the important facts and circumstances in mind. So to sum up the whole process, we can say that the investigation begins with the FIR, that is investigating the place of a crime, identifying the witness, suspects. Then there is also arrest of the suspects if needed. Then recording of the statements, confession. Then there can be search of a property or a place. Then maintaining the case diary, presenting the charge sheet before the court. So these are the things which takes into an account, that is investigation. So with this, we conclude the topic, that is investigation, that is summary trial. So summary trials are as per the CrPC, that is governed by sections 260 to 265, and they are designed to provide a summary and expedited process for the trial of certain types of offences. These trials are intended for cases where the maximum punishment is up to 2 years of imprisonment, or cases that are considered to be of summary nature by law. The objective of summary trial is to ensure that the justice is delivered swiftly without compromising on the principle of natural justice and fair trial. So no sentence of imprisonment for a term exceeding 3 months shall be passed in the case of a conviction under this chapter. Summary trials have certain unique features that set them apart from regular trials. So let's explore some of the key features of summary trials under CrPC. So the expedited process. One of the primary features of summary trial is the expedited process. This timelines for various stages of the legal process, such as investigation, filing of charge sheet, and conducting the trial, are the significantly reduced compared to regular trials. This ensures that the case progresses swiftly and is disposed of in a timely manner. Procedure for summary trial. So the procedure for summary trial is simpler compared to the regular trial. The court has a discretion to skip certain formalities such as recording detailed evidence and can rely on a summary of evidences to arrive at a decision. The rules of evidence are also relaxed, making the process less formal and more efficient. Summary trials are meant for cases where the maximum punishment is up to 2 years of imprisonment, although in some cases it may be extended to 3 years with the consent of the accused. This ensures that only offences of a certain gravity are tried summarily, and cases with higher potential punishments are dealt with through regular trials. So the right of appeal in summary trials under the CrPC is limited compared to the regular trials. So the accused can only appeal to the higher court on points of law rather than question of facts or mixed questions of law and facts. So this helps in expediting the appellate process and reduce the delay in disposal of the cases. So we'll be moving with the next slide. That is, what are the unique features of the summary trials? So one of the unique features of the summary trials is the provision for summary disposals. So if the accused pleads guilty and the court is satisfied, then the case may be disposed of summarily without a full-fledged trial. This further accelerates the process and helps in the quick resolution of the cases. So summary trials in CrPC are governed by specific sections of the code. So some of the relevant laws that govern summary trials in India are Section 260, this section defines the offences that can be tried summarily, which includes offences where the maximum punishment is of 2 years of imprisonment. Then under section 261, this section provides a summary trial by magistrate of the second class. Then under section 262, this section deals with the procedure to be followed in summary trials. Then under section 263, this section deals with the record in summary trials. Then under section 264, this section provides for the judgment in cases tried summarily. Then under section 265, that is the language of record and judgment. What the section 260 subsection 1 of the CrPC says. So according to the section 260 subsection 1 of the CrPC code, these are the things, that is a chief judicial magistrate, metropolitan magistrate, magistrate of the first class, specifically empowered in this behalf of by the High Court, may, if he thinks fit, then they can try in a summary way. So according to section 261, the High Court may confer on any magistrate investigated with the powers of a magistrate of the second class power to try summarily any offense which is punishable only with fine or with imprisonment for a term not exceeding 6 months, with or without fine, and with abatement or of attempt to commit any such offense. So this is the section which states, that is section 260 subsection 1 of the CrPC. So now I would like to conclude this topic, that is summary trials in CrPC are a very valuable tool in ensuring a swift justice for certain types of offences in India. They provide an expedited and a simplified process for the disposal of cases, ensuring timely justice, reducing delays in the judicial system. However, it is important to ensure that the principle of natural justice and fair trial are upheld, and that summary trials in CrPC are conducted in a manner that safeguards the rights of the accused. So with this, I conclude the topic of a summary trial. Now I'll be going with the another topic, that is judgment. So what is a judgment? A judgment is a court order that is the decision in a lawsuit. If a judgment is entered against you, a debt collector will have a strong tools like garnishment to collect the debt. A judgment is an official result of a lawsuit in a court. So whether a judgment is defined in CrPC, so under section 353, that is judgment. The judgment in every trial in a CrPC, that is Criminal Code of Original Jurisdiction, shall be pronounced in an open court by the presiding officer immediately after the conclusion of the trial or at some subsequent time, of which the notice shall be given to the parties or their pleaders by delivering the whole of the judgment. So the judgment is read out. Normally the court read out the whole judgment, or sometimes the court read out the operative part of the judgment and explaining the substance of the judgment in a language which is understood by the accused or his pleader. So sometimes the court will give the only the operative part of the judgment, and it is made understood to the accused. So where the judgment is delivered under clause A of subsection 1, the presiding officer shall cause it to be taken down in a shorthand, sign the transcript and every page thereof as soon as it is made ready available, and write it on it the date of the delivery of the judgment in an open court, where the judgment or the operative part thereof is read out under clause B or clause C of the subsection I, as the case may be. It shall be dated and signed by the presiding officer in open court, and if it is not written with his own hand, every page of the judgment shall be signed by him. So if the accused is in custody, he shall be brought up to hear the judgment pronounced. If the accused is not in custody, then he shall be required by the court to attend to hear the judgment pronounced, except where his personal attendance during the trial has been dispensed with, and the sentence is one of fine only, or he is acquitted. So no judgment delivered by any criminal court shall be deemed to be invalid by reasons only of his absence of any party or his pleader on the day, or from the place notified for the delivery thereof, or any omission to serve or defect in serving on the parties or their pleaders of, or any of them, the notice of such day and place. So it clearly says that if the accused is in custody, then he shall be brought to hear the judgment which will be pronounced. If the person is not into the custody, then he shall be required to hear the judgment pronounced, except where he is getting acquitted. Then his appearance can be excused. So this speaks about that. This speaks about judgment. So with this, I'll conclude the topic, that is judgment. Now we will be going with the another topic, that is constitution and powers of criminal code. So there are uh, different types of trial courts, and there are the different sentencing power given to the trial courts. So one is the sessions judge and the additional sessions judge. So in this, any sentence authorized by the law, but the death sentence to be confirmed by the High Court. Okay. So over here, any sentence can be given by the sessions judge, but if there is a death sentence given by the sessions judge, then it has to be confirmed by the High Court. Then there is an assistant sessions judge. So in this, the imprisonment can be given up to 10 years and fine. Then there is a chief judicial magistrate or the chief metropolitan magistrate court. Here the imprisonment is up to 7 years and fine. Then there is judicial magistrate of first class. So there is an imprisonment up to 3 years. Then there is a judicial magistrate of second class. In this, the imprisonment is up to 1 year and fine, but not exceeding to the 5,000. Then hierarchy of criminal courts. So there are the hierarchy of criminal courts, that is Supreme Court, High Court, Sessions Court, then Additional Sessions Judge, Assistant Sessions Judge, then Chief Judicial Magistrate, Judicial Magistrate First Class, and Judicial Magistrate Second Class. Next, that is establishment and powers of Supreme Court and High Court. So the establishment of Supreme Court is given under Article 124 of the Constitution of India, and establishment of High Court is given under Article 214 of the Constitution of India. So there is no restriction on the powers of the Supreme Court and High Court, and even the powers of the High Court are mentioned under Section 28, subsection 1 of the Code of Criminal Procedure. So, according to Section 28, subsection 1, the High Court may pass any sentence authorized by the law. Now we are moving with the next slide, that is establishment powers of court of sessions. The establishment of court of session is given under the section 9 and section 10 of the Code of Criminal Procedure. So according to the section 9, the court of sessions is established by the state government. So there is also an appointment of district judges. So according to Article 233 of Constitution of India, all district judges shall be appointed by the governor in consultation with the High Court. Now moving with the next slide, that is powers of court of sessions. So according to section 28 subsection 3, the assistant may pass any sentence authorized by law except the sentence of a death, life imprisonment, or imprisonment more than 10 years. So there are the powers which has been given to the courts. Now moving with the next slide, that is establishment, appointment, and powers of court of judicial magistrate. So under section 11 of the Code of Criminal Procedure, it deals with the establishment of court of judicial magistrate. According to section 11, the court of judicial magistrate is established by the state government. So we can see that the court of judicial magistrate, other area, that is chief judicial magistrate, additional chief judicial magistrate, then there is a first class judicial magistrate, then there is a second class judicial magistrate, then there is subdivisional judicial magistrate, then there is a special judicial magistrate. So these are the types of judicial magistrate courts. Then there is a next slide, that is appointment of court of judicial magistrate. The appointment of judicial magistrates are given under Article 234 of the Constitution of India. According to Article 234, all judges other than district judges shall be appointed by the governor in consultation with the State Public Service Commission and the High Court. So this is how the judicial magistrate is appointed. Then for the chief judicial office magistrate, the section 12 of the code speaks that any judicial magistrate first class shall be appointed as chief judicial magistrate by the High Court. The powers of the Court of Judicial Magistrate is mentioned under section 29 subsection 1. So according to the section 29 of subsection 1, the chief judicial magistrate may pass any sentence authorized by law except the sentence of death and life imprisonment and imprisonment more than 7 years. So these are the powers which has been conferred to the judicial magistrate. Then the powers of the Court of Judicial Magistrate. There is a section, that is section 29 subsection 2 of the code, deals with the powers of the Court of Judicial Magistrate. So the judicial magistrate first class may pass any sentence authorized by law except the sentence of death, life imprisonment, and imprisonment more than 3 years. And he may also impose a fine up to 10,000. Now we are moving with the next slide, that is establishment and powers of Court of Metropolitan Magistrate. So according to section 29, subsection 4, the chief metropolitan magistrate and the metropolitan magistrate shall possess the same powers of chief judicial magistrate and judicial magistrate first class. So the chief metropolitan magistrate may pass sentence of imprisonment up to 7 years, and metropolitan magistrate may pass sentence of imprisonment up to 3 years and a fine up to 10,000 in Maharashtra, and in Rajasthan the fine can be up to 50,000. So these are the powers which has been conferred to the chief judicial magistrate, judicial first class magistrate. So these are the powers which has been conferred. Now we are moving with the power and function of the executive magistrate. So under section 20 of the CrPC, it says that executive magistrate, that in every district and in every metropolitan area, the state government may appoint the executive magistrate and shall appoint one of them to be the district magistrate. The function of the executive magistrate is given under section 129, 130 and 131 and 144 in the Code of Criminal Procedure. So I would like to conclude that the powers of the criminal courts are different, but the chief metropolitan magistrate possesses the same power of a chief judicial magistrate, and metropolitan magistrate possesses the same power of judicial magistrate first class. So we also see that a sessions judge or additional sessions judge may pass any sentence, but in case of sentence of a death, it shall be subject to the confirmation of the High Court, which has been laid down under section 366 of the Code of Criminal Procedure. So with this, I conclude the topic as to how the powers of the court has been assigned to. Now, going with another topic, that is procedure to be followed for rehabilitation and social reintegration of the children. So, core principle of the juvenile justice, that is Care and Protection of Children Act 2015, is to change and recovery and not punishment. The act stipulates that children in conflict with the law and children in need of a care and security should be catered for their essential needs by adequate care, safety, growth, treatment, social integration, reintegration, and child-friendly adoption. So the principle of Juvenile Justice, Care and Protection of Children Act is made is to change and recover and not to give harsh punishment or not to give a punishment to the children. That is rehabilitation and social reintegration. So the method of rehabilitation and social integration is followed in observation homes for children contrary to the law. It happens usually when the child is not released on bail and held there by the board order in special homes or in a place of protection or with a suitable individual. So section 39 specifies that children who need treatment and security and who are not kept in families for any reason as such, or who are on a temporary or long-term basis, can be placed in such institution licensed for such children or with a suitable individual or facility. So we can see that these institutions try to rehabilitate, and there is a care and protection for the welfare of the children, that is to change and recover and not to give any punishment. So the rehabilitation, and we are moving with the next slide, that is the rehabilitation and social integration process shall be followed where the child is placed. So those in need of care and support and it live in a institutional care or in a special homes or places of security may receive financial assistance when they reach the age of 18 as stated in section 46. This is to help them reintegrate into the mainstream. So moving with the next slide, that is restoration of a child in need of a care and protection under section 40. So section 40 specifies that the competent authority under its discretion can return any child in need of a care and security to his or her parents, guardian, or fit person under assessing their worthiness to take care of the child. The committee can also provide them with the correct directions regarding anything related to the child, that is restoration and security of a child. It means that restoring to the parents, adoptive parents, foster parents, guardian or fit person. Like that is restoration of childcare institutions. Registration. I'm sorry to say, I'll correct. That's registration of childcare institution. So all organizations, whether operated by a state government or voluntary or non-government organization, have to accommodate children in need of a care and security. So these organizations have to be registered in compliance with the act within a period of 6 months from the date of commencement of the same act. So this is nothing but to register the childcare institutions. It is open shelter. So the state government may create and maintain as many open shelters as may be necessary, as mentioned in section 43, by itself or by voluntary or non-governmental organization, and such open shelters have to be registered as such in the manner specified. That is foster care. So the children in need of a support and security may be taken into a foster care, including community care by order of the committee after following that protocol as may be recommended in this regard, especially in a family which does not include the biological or adoptive parents of the child, or in a unrelated family recognized by the state government as appropriate for this purpose. This can be for a short term or it can be extended further by the concerned authorities as may be prescribed under section 44, that is sponsorship. So in order to implement various initiatives for the sponsorship of the children, it can be from any other things, that is from an individual, from group or community, then from the state government. The state government can also make rules to facilitate them, which is mentioned into section 45. Then this sponsorship will provide financial resources for families, children's homes, and special homes in order to meet the children's medical, nutritional, educational, and other needs in order to enhance their well-being. So the sponsorship conditions include that where the mother is a widow, divorced, or deserted by the family, where the child are orphaned and stay with the extended family, where the parents are victim of life-threatening illness, where the parents are injured as a result of an accident and are unable to take care of the children physically and financially. That is observation homes. So the state government may create and maintain the observation homes, which are prescribed as per section 47. It is for the temporary admission, treatment, and rehabilitation of any child alleged to be in conflict with the law in every district or a group of districts, either by itself or by voluntary or non-governmental organizations, during the time period in which the inquiry is pending. Special homes. So as per section 48, it specifies that the state government must create and maintain either on its own or through voluntary or non-governmental organizations the special homes, and it is registered in any district or group of districts, as these may be necessary for the rehabilitation of those who are found to have committed an offense, place of safety. So according to section 49, the state government shall create at least one place of protection in a state registered under section 41 to locate an individual over the age of 18 years or a child who is between 17 and 18 of age and is suspected or guilty of having committed a heinous crime. So every place of safety must be provided various arrangements and amenities for these children or individuals to reside throughout the investigation process, and also for those who are convicted of committing an offense. So the state government may specify the kinds of places that may be approved as place of protection and the facilities and services which may be given therein. Fit facility. A facility is operated by a public agency or a charitable or a non-profit entity licensed under any statute, shall be accepted by the board or the committee as being capable or temporarily assuming the responsibility of a child for the particular reason after a careful inquiry into the suitability of the facility and the child care agency as mentioned under section 51, that is managing director. So every institution must have a management committee to be set up in the manner specified under sections 53 to administer the institution and track the progress of each child. So every institution must have a managing director. The officer in charge of each institution shall encourage the establishment of children's committee to engage in such activities as may be specified for the health and well-being of the children in the institution. Inspection of registered institutions. So the state government shall appoint inspection committees for the state and district as may be prescribed under section 54 for those institutions registered or recognized to be fit under this act. So these inspection committees will compulsorily visit to all the facilities, and they will try to inspect as to whether the registered institutions are working in a proper manner or not. So such inspection committees shall undertake compulsory visit to all the facilities, the housing children in the area designated, and it shall be that at least once in a very 3 months in a group that at least which consist of the 3 members, that is including one who shall be of a woman and one of them shall be of a medical officer. Conclusion. So there is always a necessary for control process in instances of adoption and foster care. With the cooperation and sensitization of the officials involved, a shift can be brought in the entire infrastructure. To be effective in recovery and to maintain the children's well-being, daily follow-up is important. The task of social worker is all more important because children need continuous assistance even after the recovery. The main objective should be to find a loving and caring family for each adoptive child and to ensure that the child best interests are always born in mind. So this is for the child overall growth and progress. With this, I conclude the topic. So now we will be moving with the next topic, that is security for keeping peace. So basically, peace and good behavior are the two important expectations of a civil society. So the chapter, that is chapter 9 of the Code of Criminal Procedure 1973, deals with the security proceedings. So with respect to chapter 9, the term security here means guarantee, surety, which is in the form of a bond payable for the breach of condition of the bond. The object of the criminal procedure code is to ensure that the justice to the offender and to see that such offense should not be repeated. So whenever there is a bail given to the accused, we always see that there is a PR bond signing, or there is a bond which is signed by the accused to keep the peace and good behavior in the society. So this chapter speaks about that. So there is a security for peacekeeping. So always the accused is made to give a security, that is security for keeping the peace, may be taken against a person under the following circumstances. On conviction of an offense is likely to cause a breach of the peace. When a court convicts a person of an offense involving breach of a peace, the court may, in addition to the sentence that it may award for the offense, order the offender to give security for keeping the peace for a specified period not exceeding 3 years. This has been provided by section 106. The powers under section 106 of the code can be exercised only by the court of sessions or by the magistrate first class. And this can also be exercised by the appellate court or by the court exercising its powers on revision. Now moving with the next slide, that is section 106. The essential of section 106 is that it applies to any offense punishable under chapter 9 of the Indian Penal Code. Any offense which consists of or includes assault or using criminal force or committing mischief. Any offenses of criminal intimidation, any other offenses which caused or is likely to cause a breach of peace. Then under section 107, in this section, an offender is required to execute a bond for maintaining of public security, where there is likely to be disruption in public order. So in order to be effective, proceedings under section 107 have to be taken urgently, and they are immediately concerned with the maintenance of peace and order. The underlying object of this section is preventive and not punitive. The section is designed to enable the magistrate to take measures with a view to preventing the commission of the offense involving breach of peace or disturbance of public tranquility, which has been mentioned in the case of Madhu Limai versus Subdivisional Magistrate Mongur. Then we'll be going with the next PPT, that is security for good behavior. So under section 109, 108 and 110, it provides for taking security for good behavior from a person propagating seditious matters or matters amounting to defamation of judges, from suspected person and from habitual offenders. So if there is any sedition matters, or if there is any defamation matter against the judges, then there is a security of for good behavior is taken from a person. Then they are vitally connected with the preservation of public peace and maintenance of law and order. This is the first duty of every state. So the duty cannot be effectively carried out without some provisions designed to give some sufficient powers. Now we are moving with the next slide, that is proceedings against the person disseminating seditious matters. The jurisdiction under section 108 is preventive and not punitive, as rightly I have said. So the test under this section is whether the person proceeded against has been propagating seditious matters or such matters mentioned in section 108 and whether there is any fear of repetition of the offense. So in each case, that is a question of fact that must be determined with reference to the antecedents of the person and other surrounding circumstances. Then moving with the next slide, that is proceeding against suspected persons. So the object of section 109 is to check and control the person who are likely to commit an offense. And it cannot be denied that this cannot be done unless they are prevented from doing so by resorting to the provisions of this kind. So in the case of state of Mysore versus Koti Pujari, it was held that in order to attract section 109, two conditions will have to be satisfied. That is taking caution to conceal presence, and the concealment must be with a view to committing a cognizable offense. Proceedings against habitual offenders. So a person who habitually commits offenses of antisocial nature, such as those relating to the adulteration of food or drugs or foreign exchange or customs or hoardings or corruptions, then these are the persons who are habitual in nature. So the object of this section is to protect the public against the habitual criminals. So the words habit and habitually have been used in a sense of deprivative character as evidenced by the frequent repetition or commission of the offense mentioned in this section. Then we are moving with the next slide, that is Supreme Court and section 110. So the Supreme Court has directed the trial magistrates to discharge their duties when trying the cases under section 110 with great responsibility, and whenever the counter petitioner is a prisoner, he should be given him the facility of being defended by the counsel. If the state is not in a position to render the legal aid to such a person in custody, then whether it can be on account of financial stringency or otherwise, the entire procedure may be vitiated by such failure on the part of the state to render legal aid. So it says that the magistrate must discharge their duties, and if the accused is unable to defend himself, then a legal aid must be given to him. So this section clearly speaks about that. Now I have concluded this topic. Now I'll be going with the another topic, that is maintenance. So there is a law for maintenance of parents, wife, and children in India. So the law for maintenance of parents, wife, and children in India is mentioned under section 125 to 128 of the CrPC, which says that the maintenance of wife, children, and parents can be given a maintenance to the wife, children, and parents. And it is the natural and fundamental duty of every person to maintain his parents, wife, and children, so long as they are not able to maintain themselves. What is section 125 of CrPC? So according to section 125 of CrPC, a person having sufficient means is bound to maintain his wife, his legitimate or illegitimate minor child, whether it is married or not, his legitimate or illegitimate child, not a married daughter, who has attained majority, and his father or mother. Moving with the next slide, that is order of maintenance. The magistrate of first class is empowered to make any order of maintenance for those persons who are mentioned earlier. According to clause 2 of the section 125 of the CrPC, the maintenance or interim maintenance shall be payable from the date of the order, or if it is mentioned from the date of application. So according to clause 3 of the section 125 of the CrPC, if any person who is ordered to maintain fails without sufficient reasons, the magistrate may issue a warrant for levying the amount due. If the person is unpaid, if the amount is unpaid, if the amount is unpaid after the execution of the warrant, there is a provision of imprisonment for a term exceeding to 1 month or until the payment is made. So normally what happens that the judge will give an order to the person to maintain the wife, children, or parents, whichever I have mentioned earlier. If the person doesn't comply with the order and doesn't pay the maintenance, then there can be an imprisonment for a term which may extend to 1 month or until the payment is made. So then we are moving with the next slide, that is when wife is not entitled to maintenance. So under clause 4 of the section 125 of the CrPC provides that the wife is not entitled to the maintenance if she is having a adultery. If there is a without sufficient reasons, she refuses to live with her husband. And if suppose the husband and wife are living separately by mutual consent, So under this section, the claimant person is entitled to interim maintenance and expenses of proceedings. So a person can claim the interim maintenance. Say suppose the wife can claim an interim maintenance and can also claim the maintenance, that is the legal expenses or the other expenses which she is incurring day to day during these proceedings. So there are the things wherein who are the persons who is entitled to the maintenance and who are the persons who are not entitled to the maintenance. And so now moving with the next topic, that is important cases related to maintenance of parents, wife and children. So there is a case that is Nanak Chand versus Chandra Kishore 1970. In this case, the Honorable Supreme Court has held that the provision of this chapter applies whatever may be the personal law by which the parties are governed. So there are the judgment which says that the wife, parents and children has to be given the maintenance. So in another case that is Mohammad Ahmad Khan versus Shah Bano Begum 1985. So in this case, the Honorable Supreme Court held that Section 125 of the CrPC is secular in nature, which means that it applies to all, irrespective of their religion. So after this revolutionary judgment of the Supreme Court, which was truly intended to protect the interest of the Muslim woman, the Muslim women community opposed this judgment. So therefore, the Parliament passed the Muslim Women's Protection of Rights on Divorce Act 1986. So this new act allows a Muslim woman to avail the remedy available under Section 125 of the CrPC only if the husband consents to it. In the case of Daniel Latifi versus Union of India 2001, in this case, the court held that the wife can claim maintenance under Section 125 of the CrPC even without the consent of the husband. Then moving to the next slide, that is Kongni Bala versus Vishal Shai Sada Sivan 1986. In this case, the Kerala High Court also cleared that divorced wife includes divorced by mutual consent, which means a wife who is divorced by mutual consent is entitled to get maintenance under Section 125 of CrPC. So I would like to conclude the topic wherein we have seen that a wife can claim maintenance, the parents can also claim maintenance, and the children can also claim maintenance. But there are circumstances where the wife cannot claim maintenance if she is into the adulterous relationship and if there is a mutual consent, if there is a mutual consent divorce and so on, and if they are residing separately. So there are some cases wherein the wife can claim maintenance and there are some cases wherein the wife cannot claim maintenance. So I would like to conclude this topic. Now I would be moving with the next topic, that is transfer of cases under CrPC, wherein the cases can be transferred from one state to another state, from one court to another court. So this is all, it has been laid down under the code of criminal procedure code. The procedure is the procedure to be mandatorily followed by pursuing a case is briefly dealt with this under the code of criminal procedure, that is 1973. The very purpose of criminal law is the free and fair dispersal of justice, which is not influenced by any extraneous consideration. So the section 407 of the code states that it enables the party to seek for transfer of cases anywhere within the state, while section 406 states that it enables the party to seek transfer of cases anywhere in the country. So 407 states that the cases can be transferred anywhere within the state, and 406 states that it enables the party to transfer the cases anywhere in the country. The transfer of cases and appeals by Supreme Court. So under section 406 of the Code of Criminal Procedure, it confers the power upon the Supreme Court to transfer cases and appeals. The court grants the widest discretionary powers to the Supreme Court to transfer any of the appeals lying before the High Court or any other High Court of a state in the country in order to meet the ends of the justice. So the cases which can be transferred, that is who are under the apprehension of under trial by the court, then who is unable to find any proper justice being served to him, then Attorney General or Advocate General of India. So an appeal can be filed before the High Court, the Supreme Court of India. These persons who can file before the High Court or the Supreme Court of India. The powers granted by the code under section 406 to the Supreme Court is purely discretionary in nature, and the applicant is under no obligation to conclusively establish that in case the transfer does not take place, then fair justice won't take place, and the applicant is only expected to reasonably substantiate the contentions made by him under the application he has submitted to the Supreme Court. So the power of the Supreme Court to transfer the cases and appeals also extends to the transfer of cases from one subordinate court to the another court where any matter is pending in the country. However, the court where the case is pending can ensure that the Supreme Court, while transferring the case, is taking all the measures to uphold the fairness and principle of natural justice. Now, moving to the next slide, that is grounds for transfer of appeal and cases. So, to uphold the spirit of justice, the ultimate goal of any judicial system on the earth is to deliver the justice and protection of the rights of every person. The courts are highly revert institutions of justice with people having high expectations of justice, which is sought after the aggrieved party. So the courts, while deciding whether to transfer the cases and appeal from one court to another, takes into consideration the inquiries and findings as revealed by the reports carried on by the senior judicial officers such as chief judicial magistrate or any of the sessions judge. So upon request by the trial court, where the court before which the matter is pending deems the case to be outside its scope of jurisdiction due to the involvement of a substantial question of law which is outside its purview, it may request the higher judiciary to transfer the case. So we will be moving with the next slide, that is transfer of cases and appeals by High Court. So under section 407 of the Code of Criminal Procedure, it empowers the High Court to transfer cases and appeals. So moving with the next slide, that is circumstances in which the High Court may order the transfer of a case or appeal. The High Court has the authority to transfer the cases where it is satisfied that the right to a fair and impartial trial, which is guaranteed under Article 21 of the Constitution of India, cannot be exercised by any party to the suit if the case is tried by any other court which is subordinate to it. There is a certain questions pertaining to the present matter in the court are of unusual difficulty, then the order of transfer will be in the interest of the general convenience of the parties or witness involved in the suit. I'll give you a small example. Say suppose there is a matter before one court and there is also a matter before another court in the state. Then what happens that a person can move an application before a high court saying that I want to transfer this case from one court to another court because due to some difficulty I am unable to attend the court. Then the high court can transfer the case within the state from one court to another court. And if it is within the country, then it has to be moved an application before the Supreme Court to transfer the case from one state to another state. Then we are moving with the eighth slide, that is at whose instance the power of transfer are exercised. The High Court exercises power of transfer of cases at the following instances: where the lower court submits the report for transfer of an appeal or case to the High Court, where the interested parties lays before the High Court an application requesting the transfer of a case or appeal. So I clearly stated you that if an application is made by a party before the High Court to transfer a case from one court to another court, then in that things the court can transfer the case from one court to another court if it is within the state. The High Court in its own discretion can also transfer a case or appeal if it is satisfied with the fact that it would be in the best interest of the parties to the suit. Then moving with the next slide, that is procedure to be followed. So under subsection 3 to subsection 5 of the section 407 of the Code of Criminal Procedure, it lays down the procedure which has to be followed by the person who is making an application for transfer of the appeals and cases by him. So subsection 3 of section 407 of the code provides that the application for the transfer of cases to the High Court by an applicant shall be made by motion, which shall be supported by an affidavit or affirmation, except in the cases where the application is the Advocate General of the state. So whenever there is a application made for the transfer of cases, it has to be made with a supporting affidavit or an affirmation. So subsection 4 of section 407 of the code provides that where the application for the transfer of a case or an appeal is made by an accused person, the High Court has the authority to direct him to execute a bond with or without surety for the payment of any compensation which may be ordered to him by the court. Subsection 5 of section 407 of the code provides that every person who makes an application for the transfer shall give to the public prosecutor in writing a notice to notify his intention for making such an application. The notice should be accompanied by the grounds on which the application is made. This section also instructs the court not to make any order on the merits of the application so submitted by the person unless at least a time period of 24 hours has elapsed between making of such a notice and hearing of the application. That is stay of proceeding to the subordinate court. In this section, the provisions that is subsection 6 of section 407 states that wherein application for transfer of cases from one subordinate court is lying before the High Court, then the High Court may, if it deems fit in the interest of justice, stay the proceedings in the subordinate court on such terms which it may find appropriate. However, if such an order is made by the High Court, it should not have any impact on the Sessions Court power to remand, which is guaranteed to it under section 309 of the code, where the application is dismissed by the High Court. So under subsection 7 of the section 407 of the code contains provision regarding the cases where the High Court dismisses the application made to it under subsection 2 of section 407 of the code. So if the High Court finds that the application for the transfer of appeal or case was vexatious and frivolous, it may order the applicant to pay a compensation of and upon not exceeding 1,000 rupees to a person who had opposed the application made by the applicant. So if the court feels that the application for which the transfer of case or appeal is vexatious or frivolous, then the court may order the applicant to pay a compensation, that is transfer of cases and appeals by the sessions judge. So the sessions judge are also conferred with the power to transfer cases and appeals by the code, which has been mentioned under section 408. So subsection 1 of section 408 provides that whenever sessions judge finds it expedient to transfer a case to meet the ends of justice, he has the authority to transfer such cases from one criminal court to another court within his sessions division. However, section 408 subsection 2 provides that the instance on which the sessions court can transfer the cases, that the section provides that the authority to transfer the cases within the sessions court can be exercised by it at the instance of the report in this regard submitted to it by the lower court. The provisions under subsections 3, 4, 5, 6, 7 and 9 of the section 407 shall be made applicable to the sessions judge while making any order in regards to the power vested on it by subsection 1 of section 408 in the same way as they are made applicable to the High Court while exercising its exercises the provisions mentioned under subsection 1 of section 407 of the code. Then we are moving with the next slide, that is withdrawal of cases and appeals by the sessions judge. Section 409 of the code of criminal procedure contains various provisions regarding the power of the sessions judge to withdraw the cases and appeals. So subsection 1 of section 409 provides that the sessions judge not only has the power to withdraw any case or appeal, but also has the power to recall any case or appeal which he had earlier transferred to any additional sessions judge or chief judicial magistrate who is subordinate to him. Section 409 subsection 2 provides that the power of recalling the cases by the sessions judge from any additional sessions judge can be exercised by him at any time before the commencement of the trial of the case or hearing of the appeal before the court of additional sessions judge. So in the case of Surendra Kumar versus Vijayawada, the court held that the authority of transferring such cases from one criminal court to another court within its sessions division conferred on the sessions judge by section 408 subsection 1 of the code is an independent judicial power and is not subject to any bar provided under subsection 2 of section 409. Now moving with the next slide, that is withdrawal of cases by judicial magistrate. Section 410 of the Code of Criminal Procedure contains provisions regarding the withdrawal of cases by judicial magistrate. So any judicial magistrate has the authority to recall any case which he had transferred to another magistrate under section 192 of the code and may inquire into the case of his own. And the subsection 1 of section 410 of the code grants the power to the chief judicial magistrate to transfer any case from one magistrate subordinate to him, as well as the power to recall any case which he had earlier transferred to any magistrate subordinate to him. So when the chief judicial magistrate recalls a case, he has the authority to himself hear and try such case, or he may refer the case to any other magistrate who is competent to hear and try the case. So section 410 of the next slide, that is section 410 of the code It contains a provision about the withdrawal of cases by the executive magistrate. The section provides that any district magistrate or subdivisional magistrate has the authority to withdraw any proceedings which stated before the court to any magistrate who is subordinate to it for the disposal of the case. It can be withdrawn or recall any case which he had earlier transferred to any magistrate subordinate to it and dispose of the proceedings of the case himself or refer the same for disposal to any other competent magistrate. Then section 412 states that the reasons to be recorded. So section 412 of the CrPC states that a sessions judge or magistrate judge making an order under section 408, section 409 and section 410 or section 411 shall record his reasons for making it. So whenever there is a transfer or whenever there is an withdrawal of any applications or whether there is a dismissal of such application for transfer, then the reasons should be recorded and the judge should make the judgment by recording his by giving his reasons on it. So I would like to conclude that transfer of cases does not alter the nature of the trial or relief which is provided to the parties to the suit. It is a mechanism ensuring the parties that they are rendered justice. The authority of transferring of criminal cases from one court to another court is conferred upon Supreme Court and the High Court and the Sessions Court. So with this, I conclude the topic, that is how the transfer of cases takes place between one court to another court within the state and from one court to another court within the country. So with this, I end this webinar and I would like to thank the PLEA for organizing this webinar.
Thank you so much for your dedication and the effort that you took for the students.